Senator Creighton, you recognize suspend the regular order of business on House Bill 2127.
Thank you, Mr. President. Members, House Bill 2127 is a lifeline for small businesses, entrepreneurs, job creators in Texas who need consistency and certainty to invest and expand and grow. Look around the nation and you'll see that businesses and families are still choosing to move to Texas beyond any other state because they believe they can be a part of a Texas miracle to have the best opportunity to find prosperity in America. It's our obligation as lawmakers to keep that dream alive, a dream that allows Texas to be the only remaining state where you can start a business in your garage or your kitchen and still have a fighting chance to reach your dreams. Texas leads in job creation, business relocation, and we're the one-way U-Haul rental destination of America. However, this prosperity is not guaranteed, and we as lawmakers cannot afford to take it for granted. If we want to remain the envy of the nation, we must pass this bill to prevent a patchwork of regulations. And for many sessions, I've pursued legislation that addressed specific instances where activist cities were enacting job-killing ordinances so that we could reverse course on that happening. It's clear that this issue is not going away several sessions later. And that's why the Texas Regulatory Consistency Act, a top priority for our Texas businesses this session, one of the top priorities of the Texas House. That's why we bring this forward again sessions later, after many of us in the Senate have continued to keep this as a priority. This new approach gets ahead of potential overreach in the future, establishing that Texas and the state legislature is the correct venue for decisions that impact our statewide economy. This bill is about jurisdiction, members, and it's also about the state constitution. And just as the federal government is the correct venue within certain areas of the law, the state is best suited to regulate the issues of labor and commerce outlined in this bill. Texas cities will oversee a very long list of issues after this bill is passed, including public safety, transportation, zoning, growth, and many other issues. Members, we know that the rest of the nation still sees Texas as the place to seek opportunity and prosperity. We all know that the Texas economic engine is not an accident. It's a direct result of the policies that we've passed here in this legislative body to encourage investment and to encourage others around the nation to understand that Texas is still the greatest example of hope and opportunity and a future for families if they choose to move here. It's also a direct result of the burdensome regulations and red tape that we fought against. And the Texas Regulatory Consistency Act is perhaps the most pro-business, pro-growth piece of legislation we'll consider this session, not because of what it creates, but because of what it prevents. And this will help these business owners keep their doors open, keep people employed. This legislation benefits Texas's small businesses by letting them be in charge of their own policies. It also benefits large businesses like Amazon, Southwest Airlines, and H-E-B as examples that operate in dozens of Texas cities to understand that regulatory issues and policies that affect commerce should be statewide and not regional. Mr. President, I move suspension of the regular order of business to take up and consider committee substitute for House Bill 2127.
Senator Eckhart, what purpose?
To ask questions of the author.
Do you yield?
Yes, I yield.
Thank you so much, Senator Creighton. This bill is of particular interest to me, of course, because I come from local government. And so my concern is that I'm going to become a local government official again as a state senator because of this bill. I loved being a local government official, but the pay was a lot better. So I have a few questions. Is the legislature prepared to write county and city ordinances? Because this bill will require that.
Senator Eckhart, this bill doesn't require anything other than what the day-to-day should be now within our Texas Constitution and Texas statute.
Well, we'll get to the Constitution
So
in a minute.
as I mentioned in my layout, the state constitution under Article 11, Section 5, provides that no charter or any ordinance passed under said charter shall contain any provision inconsistent with the Constitution of this state or the general laws enacted by the legislature of this state. So rather than you returning to be a local elected official, you're right where you need to be if you're concerned with issues tied to labor or the agricultural code or business and commerce issues or certain finance issues, many issues within the code itself. This is the jurisdiction we should be making decisions on for the impact in the future of Texas businesses, so that statewide is the impact for those businesses struggling every day to comply with varying different municipal ordinances that aren't found with authority either in our Constitution or state statutes.
Do you believe that the Texas legislature sets floors below which local governments should not go in terms of their regulatory authority?
Well, I think I was really direct on exactly that question. I think that the constraints are the Texas Constitution, and with the language in Article 11, Section 5, it's very clear.
May I ask you to answer the question?
Yes, the Article 11, Section 5 is exactly the restraint that you mentioned. So I was answering the question. I answered it in my layout. And
I'm not interested in hearing the layout again. Do you believe that the Texas legislature establishes floors below which local governments may not go?
Fourth time in a row, the Constitution is the floor and the ceiling.
So you believe that the Texas legislature sets both floors and ceilings, floors below which local governments cannot go, and ceilings above which local governments cannot go. Is that a fair restatement of what you just said?
The state constitution and our state statutes lay that out very clearly. Yes.
So let's go to some clarity here. When a contractor who is pursuing a government contract, a local government contract, does not succeed in getting that contract because the local government went above the floor set by state government, do you believe that the legislature should correct that?
Well, obviously, why I'm bringing the bill forward. If I didn't believe that, I wouldn't be bringing the bill forward, right? I mean, cities not staying in their lane is exactly why we have the litigation we have in this state. It's exactly why we have businesses panicking in this state. It's exactly why we have single mom, small business owners from your district in committee every time we open the doors of the committee with this bill on the agenda for years and years now. The same witnesses and new witnesses coming back, absolutely panicking on how to comply with the litany of different ordinances that are not constitutional, that are not found within the parameters of state statute. So when you mention floors and ceilings, I don't agree with couching it in that way. I think that it's very clear in our Constitution that if the charter itself does not find the authority within the general laws of the state, that they shouldn't be involved in going outside of the bounds of that statute. They should be coming to you or me or other legislators to have a bill that is considered in our public hearings and that, if passed, would have statewide impact on all businesses, not just some trying to comply with 30 cities and their different approaches.
Then I'm going to ask you the same question, but with regard to a ceiling. If a contractor going out for a local bid does not win that bid for local contract because the local contract had something below the ceiling of what's required by state legislation, do you think we should correct for that as well?
Give
What
me
I'm getting at, let me
a more
jump to the
granular.
case.
I mean, you're on floors and ceilings. Give me hypotheticals. Yeah.
So if a local government contract goes above the floor of a minimum wage, you think we should correct for that in legislation, correct? Is that fair?
You know, we've seen the different minimum wage policies around the nation that have been enacted in cities like San Francisco and Seattle and many other cities that have caused businesses to terminate employed workers, and that, yes, it's been counterproductive. That those decisions and those compensation policies should be decided here.
You similarly feel that if a local government contract goes below the ceiling of what's required by the legislature in a contract, what I'm saying is you want them to have no latitude. The legislature should set the floor and the ceiling, and there is no deviation in between that floor and ceiling.
Unless we provide for that deviation. So in the bill itself, you'll have different examples that are tied to payday lending. You'll have different examples tied to, you know, the regulation of pets and the sale of pets. You have a different authority allowed through statute, not only that currently exists in statute, but also with what we're doing with this bill.
What if the legislature is silent on a floor or ceiling, says nothing at all, but a contractor loses out on the contract because the local entity put something in that the legislature has never said anything about at all?
You know, whether you're talking about fair pay ordinances or paid sick leave or hiring or scheduling practices, all of those examples fit into the category that you're mentioning. This legislation is not about contracts. It's about jurisdiction and the Constitution.
So let's take a different example. What about a developer who isn't getting to build what they want on the piece of property that they own? Should the local entity not be able to do any zoning that we are not specifically prescribing?
Zoning is still allowed in the bill because state statute allows for municipalities, home rule cities to work within that space. So, of course.
I did note that it allows home rule cities roads and taxes. So that's good. We don't have to deal with potholes, pothole complaints. Let's take a third. What about a property owner who's angry about an otherwise legal new neighbor who's moving in, say a puppy mill? The local government can't do anything about that until the legislature directs them to.
That's correct, Senator Eckhart. Look,
what about a gambling parlor?
I just mentioned the sale of pets in the previous answer. So I'm not going to be able to interpret every code for you. You're going to have to do that.
So true.
Yeah, exactly. And that is the point of the bill, right? That you're making the point to why we need the legislation is if it's found in statute, cities can work within those parameters. If it's constitutional, they can as well. If something in addition to that is needed, they can come to the legislature. That's not radical. That's actually the opposite of radical. That's the norm.
So you think that's the norm? We're going to get to that.
What we've seen with the actions taken by cities, the reason why they're getting slapped down in the courts and they're losing in this effort in so many different categories is they're impatient with the results of the Texas legislature. I guess our conservative results, and they're pushing forward outside that lane, and we're having to speak to that.
So a municipality or any other local government, if they have any inferred authority from the legislature, they still have to wait for puppy mills, gambling parlors, massage parlors, payday lenders, and they have to wait until the legislature specifically acts. Is
No.
that correct?
All of those examples are not going to be any different after this bill passes for the city to be able to regulate them. So no, every single one of those examples would not be changed at all with this legislation passing.
Well, municipalities already have regulations with regard to massage parlors, puppy mills, and payday lenders, don't they?
They do, and some of them have, sick leave and scheduling requirements and hiring requirements, and some of them give, complete subpoena power to city employees over private businesses. A lot of those different examples, this legislation is speaking to exactly that. So it doesn't matter if they already have it. Some of them, what they already have is not constitutional and not authorized in state law.
Let's go to the Constitution, because you have mentioned that over and over again, and I agree with you about what the actual words say. Where I disagree with you, however, is in what the courts have decided it means. Are you aware that it's longstanding case law that what that provision means is if a home rule city can do anything that isn't specifically prohibited by statute? You're aware that that's the interpretation of that constitutional provision.
That's the difference in a home rule city and a general law city, correct?
So your bill changes that interpretation of the Texas Constitution, doesn't it?
Correct.
So doesn't this require a constitutional amendment?
No, I mean, we act within statute, with 10,000 other bills in this session, just like we're acting with this one.
So you're just eradicating the legal construct of a home rule city?
We're just clarifying and evolving over time with policy as we do every other year, January to May.
But you are agreeing with me that you are eradicating the interpretation that a home rule city can do anything by ordinance that isn't specifically prohibited by statute.
Up to this passage of this bill, yes. That's the difference between home rule and general law.
Thank you. And with regard to occupying the field, I know that the bill specifically says in a field of regulation, the bill prohibits a city from adopting or enforcing an ordinance regulating conduct in a field of regulation that is occupied by provision of this code. What does it take to occupy the regulatory field? Does it take?
If it's an ordinance tied to pesticides, it would be found in the agriculture code. So that would be occupying that field.
So if the agriculture code says anything about any pesticide, then local governments cannot regulate any pesticides.
And conversely, if the ag code says that local government can regulate pesticides, they would obviously be able to, as they do now.
So if a code touches on an issue, it has occupied the field.
We write statute that's ambiguous on purpose and vague, and sometimes we're very prescriptive, and we choose to go the other direction if it's ultimately decided to be too vague and parties are in conflict over it, then the courts would clarify that.
So it sounds like we're going to have a lot more courts clarifying stuff. Would you agree?
The judicial branch is what it is. That's what it's there for. But no, I don't believe that this bill would enhance any additional litigation. I think it's very clear to most cities in Texas what is in bounds to follow state statute and the Texas Constitution and what is not. That's why most cities are not advancing ordinances like we're talking about, but many are.
Well, when I was a county attorney, assistant county attorney, one of my jobs was to go looking for express authority for the county to act because counties, unlike home rule cities, can only act when they are specifically allowed by the legislature. So it's true, counties have to go looking for express authority, but cities have not traditionally. Don't you think that that means cities will now lay back and wait for the legislature to act, even though they are governing 365 days of the year, 24/7, and we only meet 140 days every other year?
I don't agree that most cities act really much different than counties do. I understand the distinction, and there are some very clear differences, but most cities in Texas understand very clearly that they must act within the state constitution and the powers granted to municipalities, and also within current state statute. But some cities are not abiding by that, and that's what this legislation is about. It's simply a reminder about jurisdiction and making sure that a litany of and a patchwork of different ordinances across this state that are an impossible compliance nightmare for businesses is anti-business, it's anti-growth, it's anti-job creation, and it's anti-Texas to allow those ordinances to be passed. That's what this bill is about.
I can tell you that in working for a county for 20 years, when constituents came complaining of incompatible uses, of the inability for zoning in counties and whatnot, I said, then you should want to be annexed into a home rule city where you can get that kind of service. So basically, you would like all of Texas to behave like a county rather than like a home rule city.
As long as home rule cities are acting within statute and within the provisions of the state constitution, I think that they're well within their right to continue to do what they do and do it well. And as I mentioned, many of them, most of them already do that and already understand through their general counsel and city attorney and city managers what is appropriate business to advance and what isn't. But we have many examples also in Texas and right here down the street where that has not been the case.
Why not just get rid of cities?
Why not get rid of cities? There's no intention, it's signaled in any of this legislation to get rid of municipalities or counties or any other local governing entities. But I can tell you one thing, there is without a doubt certainty in signaling with this legislation and other bills that a reminder that jurisdiction matters and that the state constitution matters and that our businesses matter, because our businesses are panicking, coming into our hearings and calling into our offices saying, we have to lay people off. We cannot keep up with the compliance differences up and down I-35 alone in the different municipalities that have set these different ordinances.
We're the 9th largest economy in the world if we were our own nation, but you're saying that business is having trouble here?
Yes, I am. And the reason why there is an appropriate tension there is what we do in this building is the reason why we provide the tools to entrepreneurs to take the risk, to create the jobs that bring us that distinction of being the 9th largest economy in the world. But the only difference that you and I would probably have on that distinction is I am striving for number 1, not number 9.
If we were our own nation, we would be number 9. We're not a nation, so we can't be the number 1 nation. You're aware of that, right?
It's all based on GDP. We're number 9 over so many nations on this planet. So yeah. I really don't hold myself back on setting any goals, nation or not.
That's a very patriotic statement to make. I'm being facetious.
Appreciate it.
And you are aware that the predominance of that gross domestic product is coming from our home rule cities, businesses inside our home rule cities, correct?
I'm aware, but I'm also aware that when Tesla and Caterpillar and Samsung and others, Hewlett Packard, when they come here, Exxon, it's interesting that many of them choose to be just outside of those home rule city limits and in the county's jurisdiction. And isn't that amazing that those real estate choices and those site selection teams are that careful about avoiding the home rule city boundaries? And it's exactly for reasons like this bill clarifies.
Do you believe that state legislation would have occupied the field if it is silent on the issue?
If it's silent on the issue and it's not prescribed in state statute as granting the home rule city authority, then they would need to approach, just as TML provides a legislative priority list every session. And sometimes we're called into special sessions. We may have one soon. And those types of bills and those types of policy changes would be in the appropriate environment right here in the state capitol to consider, or whether they're rejected or whether they're adopted.
Thank you for answering my questions.
Thank you. Appreciate you, Senator Eckhart.
Senator Menendez, what purpose? You can continue. If you need to take that, I can call someone else. Are you good? Okay, Senator Menendez.
Thank you, Mr.
What
President.
purpose?
For questions of the author.
Do you yield?
I yield.
Thank you, Mr. President. Senator Creighton, got a few questions, and I was on page 2 of your bill, just so that I understand correctly, everything that's in each of those sections, if it falls under the Ag Code, business and commerce, finance, insurance, labor, local government, natural resources, occupations, and property, you're saying that in those areas, cities cannot pass an ordinance. Is that how I'm trying to understand exactly what's protected and not protected from cities being able to regulate, because and which laws are going to be impacted by this? And so if you could help me a little bit understand this.
Well, it's consistent with my exchange with Senator Eckhart. Obviously, there are a tremendous number of ordinances that are found within the authority granted in these different codes. So we talked about zoning. We talked about
Zoning gets to stay?
correct.
Okay.
The zoning is chapters 211 through 250 in the local government code. So we talked about animals. We talked about payday lending. I believe Senator Eckhart mentioned game rooms, massage parlors, public safety, police, fire, jails, community planning, development. All those examples are found within state statute authorized by our Texas Constitution, Article 11, Section 5. And that's why most cities in Texas continue to be in line with the expectations and the jurisdiction that we've provided, but some are not.
Do cities, one of the most difficult to craft but important ordinances we passed a long time ago when I was on city council was our sexually oriented businesses ordinance, because we had to comply with First Amendment rights of these people, these businesses, but we also wanted to make sure they were far enough distance from schools, from churches, from neighborhoods. And so we worked very hard. We ended up getting sued. We won, but we have a pretty strong sexually oriented business ordinance in San Antonio, which dictates where people can and can't put these businesses. Would this preemption law, do you think that those businesses could sue us based, if this bill passes, and say that the city is now preempting their rights, or that the state now has the right to regulate that?
I do not. There's no disruption with the passage of this bill on any work that you or others in the city of San Antonio have accomplished in that space. That's Section 243 of the local government code, and there is no change. Again, this bill is about clarifying jurisdiction on the ordinances that cities can work within based on the authority granted either by state statute or by the Constitution, and that is one of the examples that is already found in statute.
So payday lending businesses, do we have a payday lending ordinance in place? Does that exempt, or does that become?
That's exempt, and the House allowed an amendment on that even further clarified that.
Okay, very good. I know that Senator Miles has an amendment for payday lenders that unfortunately he's not able to be here, but we're planning on presenting. Does the bill affect ordinances protecting non-discrimination ordinances that, let's say, again, my city, and I know that cities of Dallas, San Antonio, Austin, Fort Worth, Arlington, El Paso, Brownsville, Denton, and Plano, and others have created a non-discrimination ordinance in order to ensure protections for people based on against discrimination based on their race, color, religion, sexual orientation, public accommodation, employment, and housing practices. Does this bill nullify those non-discrimination ordinances?
It does not, and that was also clarified in the debate with the House author as well. The NDOs are not affected by this legislation.
Very good. I'm glad to hear that. Maybe then obviously the amendment we have later might be acceptable to the author. And then let's see, I think the last couple ones we have here, and I think I heard you, but it was hard to hear. Does the bill affect cities that have passed puppy mill ordinances for the sale and distribution of puppies?
Again, that was another clarification by House amendment during the discussion on the House floor. And so, no, the sale of puppies can continue to be, cats and dogs, animals can continue to be regulated by municipalities.
Thank you for taking my questions. Appreciate it.
Thank you, Senator Menendez.